pages. I believe approximately 2 pages of the transcript that are relevant to the actual shooting, and another group of pages, approximately 10 pages, I believe, that are relevant to the issue of the neighbor upstairs or the visitor upstairs appearing on the landing. So that's what we would ask be those portions of the deposition that are relevant be used, not all 228 pages, which are most of which are not relevant.
All right, Mr. Matthews.
Well, Judge, with reference to the Mattingly deposition, I concur with what Ms. Whaley just stated. That deposition was kind of all over the place, and it devolved into some personal attacks back and forth between the witness and the questioning attorney. And I agree that it was it would be very difficult to redact that, and I think that's why we decided not to use it. On the other hand, with reference to Detective Cosgrove's deposition, and I don't believe the whole 228 pages is testimony. There's a lot of stuff at the end, but that is just citations to page numbers and so on. But the entire deposition is related to the events that occurred on March 13, 2020 at 3003 Springfield Drive, and I believe that it's all relevant. And I don't believe there's a whole lot of material in there that is not probative or relevant. And with reference to the specific sections that Ms. Whaley just cited, the second portion of the transcript that she would like to use is a section where language is used referring to Brett Hankison as angry and yelling, and basically the attorney doing the questioning testifying. There was no opportunity for Brett Hankison to cross-examine on that issue, for that matter, and for that reason, I think if you take it out of context or just cherry pick it out of the deposition, it's very prejudicial to Mr. Hankison. But if it's read in conjunction with the entire deposition, it's a little less stinging. So that's why I feel like it's an all-or-nothing proposition there.
Who was there representing Mr. Hankison at Mr. Cosgrove's deposition?
Kyle Vaughn and Ibrahim Farik.
Okay. All right. Is there a way that you all can get me that deposition today?
Yes, Your Honor. We actually, I could email the transcript, and the video is, I believe, was delivered to the court Friday. Our investigator was going to come and pick it up, and it's probably still there. The video, it's a flash drive with the video, but we can email the transcript.
Okay.
And it is 200 pages of testimony. I just looked at it. 200 of the 228 is actual testimony.
All right. So what I would ask you both to do then is to take another look at that transcript, and each of you give me the pages that you believe are relevant to our trial. And then I can make a ruling based on that.
Can I ask, Barbara, do you have any idea how long the video is?
I do not. I haven't seen it. Mr. Farrell might know since he was present for it. I don't know.
Mr. Beck, were you present?
No, Your Honor, I was not. Mr. Cosgrove was represented by Bill Bramall and Scott Miller, who represented him with regard to his employment situation with LMPD, but I was not present.
Does Mr. Cosgrove have just a guess as to about how long this video deposition lasted?
Judge, this is Myles, Cosgrove. If I had to guess, it would be 2 hours to 2.5 hours.
Okay, thank you. All right. Well, based on Ms. Whaley's statements, Mr. Matthews' statements, taking in conjunction what Mr. Beck has told us that he has learned from the Department of Justice, I will find that Mr. Cosgrove does have a legitimate Fifth Amendment privilege that then makes him an unavailable witness for the purposes of our trial, and then we will sort through the civil deposition as to which parts, of, if any, are to be admissible before the jury in this trial. All right. Anything else on that issue, Ms. Whaley?
No, Your Honor.
Or Mr. Matthews?
No, Your Honor.
Or anything, Mr. Beck, that you wanted to add?
No, thank you, Your Honor.
All right. So I'll excuse Mr. Beck and Mr. Cosgrove. Thank you all for calling in. Ms. Whaley and Mr. Matthews, if you'll remain on the line just for another few moments so we can maybe preliminarily talk about jury instructions.
Yes. Thank you, Your Honor.
Thank you. All right, Ms. Whaley, I think I had mentioned on Friday that I was hopeful that we could just at least preliminarily talk about the instructions. Obviously, it's 3 counts of wanton endangerment in the first degree. Anything else that you were going to propose, Ms. Whaley?
No, Judge. That's what we have drafted some proposed instructions.
Okay. And Mr. Matthews?
Yes.
Judge, I am working on the assumption that you have some standard boilerplate instructions that you give in a criminal case.
Yes.
In addition, I have prepared 6 proposed instructions that I will finalize this afternoon, but they all relate to justification and the United States Supreme Court decision of Graham versus Connor.
Can you give me that site?
Yes, if you give me just a second here.
Sure.
Graham versus Connor is 490 U.S. 386. It's a 1989 case. I can give you the Supreme Court or lawyers or LED sites too, if you would like.
Oh no, that's fine. That's fine.
Okay.
Thank you for that. All right. So if I could ask,
Your Honor,
go ahead.
we have a case as well. I can actually email that along with our draft instructions,
Okay.
which is Commonwealth versus Caudle. And that site is 540 Southwest 3rd, 364, which is the Kentucky Supreme Court, 2018.
Okay. All right. Thank you. And then if both of you would email your proposed instructions to my staff attorney, and it's Bob McClure, MCCLURE at kycourts.net.
So there's no dot, it's just Bob McClure.
No.
Yes, we will do that.
I will do that also.
Okay, thank you. And so I'll be looking for that, the transcript. I'll take a look at these cases that you've cited, and then when you can get the instructions emailed as well, I'll take a look at those. All right. Anything
Thank
else?
you, Judge.
Anything else we should talk about today?
I don't think so.
Okay. Anything, Ms. Whaley?
Judge, there is one other issue in regard to the witness, Jon Mattingly. We would ask for a missing witness instruction which has been approved by both the U.S. Supreme Court and the Kentucky Supreme Court regarding a witness who has claimed the Fifth Amendment, and obviously a jury cannot be told that, but under these cases, which I can also email, Clayton versus Commonwealth, which is a 1990 Kentucky Supreme Court, 786 Southwest 2nd, 866. And then Bowles versus United States, that's Bowles. And that's, let's see, the U.S. Site, I don't have the Bowles site.
If you could just email it to me when you get the chance.
Yes. And under those cases, the jury can be advised simply that in the case of Jon Mattingly, potential witness, let's see. The court, I'm just going to quote from the Bowles versus United States. The court can instruct the jury that they should draw no inference from, and this witness was Smith's absence, because he was not available to either side. And that's it. That the jury should draw no inference from his absence because he was not available to either side. So we would ask that instruction be given regarding Mattingly. If for some reason we end up not using Cosgrove's deposition, then we would ask it also be given in regard to him.
Do you think if I gave such an instruction as to Mr. Mattingly that the jury may conclude that as a result of his injuries he was not available? I don't know that there's been any testimony. You know, the testimony that I've heard so far in the trial was that he was shot, that it was serious, that he was taken to the hospital. Certain people saw him at the hospital. That he was expected to live, and I think that's where it's been left. I don't think, there's been much testimony about his recovery since that time.
Well, we could put a witness on to establish that he recovered and has retired.
Okay. What I don't know.
I guess, can I
Mr.
interject
Matthews,
here for a minute?
I didn't know if you'd had a chance to give this any thought at all, if this is new information to you regarding this missing witness instruction.
Well, I mean, my feeling is that he has never formally been called as a witness and failed to appear, so why would we call attention to it?
Well, because we can't call him when he's going to assert the Fifth. He can't be called in front of the jury.
Right.
Well,
but if you want
I guess I would have to think about it more, but
sure.
I'm not sure it makes much difference.
All right. If you want to, spend some time this afternoon looking at that as well, and anything that you might want to respond, if you'll just email that to me or to my staff attorney also.
I will do that.
Okay. All right. Then I will look forward to seeing you all tomorrow morning at 9:30.
Thank you, Judge.
Thank you.
Thanks. See you then. Bye-bye.
Bye.
See ya. Bye.